On March 31, 2026, China's State Council Order Number 834 came into force. It is a single legal instrument, 11 chapters, sitting on the table in front of us right now. The surface reads like routine regulatory housekeeping, a consolidation of existing rules, some new definitions, a unified enforcement mandate. The deepest layer is an entirely different kind of object. It is the architecture that makes all previous restrictions enforceable at once, and the shape of that architecture is the most precise record yet of how deeply a decade of external pressure actually landed. We are going to open this document from the outer casing inward, the mandate language first, then the consolidation mechanism, then the compliance obligation layer, and finally the buried structural fact that explains why every other layer looks the way it does. The outer casing is the instrument itself. Order number 834, formally titled Provisions on the Security of Industrial and Supply Chains, carries the authority of a State Council administrative regulation. That places it below the level of national legislation and above ministerial rules, binding on all administrative bodies and all entities within its jurisdiction. The choice of instrument is a data point before a single substantive provision is read. Administrative regulations at this level are selected when speed and breadth of coverage matter more than the deliberative process of full legislative drafting. The State Council treated supply chain security as urgent enough to bypass the slower path, and that judgment about urgency is encoded in the document's formal classification, not in its preamble. No independent legal commentary had produced a clause-by-clause English analysis as of this recording, so the structural reading here is drawn from the order's own chapter headings, its defined terms provisions, and the initial alerts from foreign legal counsel. The first layer down is the consolidation mechanism, and it is where the document's true function becomes visible. The order integrates four previously separate legal and administrative regimes. Export controls had been governed under the 2020 Export Control Law. Countermeasure authority rested on the 2021 Anti-Foreign Sanctions Law and related measures. Data security requirements flowed from the 2021 Data Security Law as applied to supply chains. Investment screening operated through an evolving national security review process for foreign investment. These four regimes had shared jurisdictional space for years without sharing enforcement definitions or a unified triggering standard. Each had its own administrative home, its own vocabulary, its own procedural clock. The order creates the shared standard that was missing. The fact that this consolidation was necessary in March 2026 is itself diagnostic. For years, China's supply chain countermeasures were legally fragmented enough that a firm with the right legal architecture could treat them as separate compliance silos, meeting each requirement in isolation without any single action producing a response across all four regimes simultaneously. The order's existence is a confession that the previous architecture had gaps wide enough to be exploited. Each of the four regimes was built reactively. Export controls expanded in response to entity list additions beginning in 2018. Countermeasure authority came after specific sanctions on Chinese officials. Data security rules tightened after Western scrutiny of Chinese data flows, and investment screening developed in parallel. Their fragmentation was a historical artifact of reactive construction. What the order replaces that artifact with is a design system, and those are structurally different things. The next layer down is the compliance obligation layer, and this is where the jurisdictional reach of the instrument becomes operationally significant. Order number 834 imposes what the text describes as whole-of-firm obligations. The obligation attaches to the entity, not just to the transaction or the product. The jurisdictional hook is operation within China, not incorporation in China. A foreign firm with a Chinese subsidiary, a Chinese joint venture partner, or Chinese domiciled data infrastructure falls within scope. The precise application of that phrase to firms with only digital or remote service exposure to China had not been settled by implementing guidance as of this recording, and that boundary remains genuinely open. The whole-of-firm structure addresses a compliance pattern that had been standard practice. A foreign multinational could configure its Chinese entity to meet local requirements while leaving its global procurement, intellectual property, and data structures outside Chinese legal reach. Subsidiary-level compliance was the workaround, and it was effective because the previous framework's jurisdictional reach stopped at the entity boundary. The order's architecture is a direct response to that configuration. The configuration is legible in the statute the way a healed fracture is legible in an imaging scan. The repair tells you exactly where the break was. The deepest layer is the unified triggering standard, and this is what the decade of successive Western restrictions ultimately produced in legal form. Under the previous fragmented system, each of the four regimes required a separate administrative finding under separate legal authority before enforcement could proceed. A determination that a supply chain relationship posed a national security risk would move through one channel while the same relationship sat undisturbed under the other three. The order eliminates that procedural separation. A single administrative determination under the unified national security mandate can now trigger export control review, countermeasure authority, data security audit, and investment screening simultaneously under a shared evidentiary standard. The parallel switches are gone. To render what that shift means structurally, think of a building where the fire suppression system, the structural alarm, the evacuation protocol, and the insurance notification each had separate trip switches in separate rooms, each requiring a separate key. Order number 8, 3-4 installs one panel that throws all four switches at once. The individual systems did not change. What changed is that they now share a single point of activation, and the distance between a triggering event and a full spectrum response collapsed to zero. That is the only analogy this dissection needs, because the mechanism it describes is the one fact that does not render well as a number or a layer name alone. Each successive restriction from 2018 onward, through the advanced chip rules of 2022 and 2023, forced China's countermeasure apparatus to respond through whichever legal channel was fastest. The result was a patchwork. Order number 834 is what a government produces when it has had long enough to study the patchwork and replace it with load-bearing structure. The restriction is not just visible in the chip architecture of the devices those rules were designed to control. It is visible in the chapter headings of the legal instrument the restriction made necessary. What this dissection cannot settle is the distance between the order's architecture and its operational effect. The text establishes the legal mechanism. It does not establish enforcement velocity, administrative capacity, or the appetite of Chinese regulators to trigger the unified standard against a major foreign firm in the near term. The whole of firm jurisdictional reach is stated plainly, but its application to remote service exposure has not been tested by guidance or by any enforcement action documented as of this recording. The integration of four regimes also assumes that the four administrative bodies involved share information and coordinate action in practice. The order mandates that coordination, but mandating institutional coordination and producing the institutional muscle memory to execute it are different deliverables on different timelines. One further limit, the order came into force on March 31, 2026, which means the full landscape of firm responses, legal challenges within China's administrative system, and bilateral diplomatic reaction remains unresolved at the time of this analysis. The dissection establishes the architecture with confidence. It cannot yet confirm that the architecture performs at the speed and scope the text specifies, and those are different claims. What the whole object proves, taken layer by layer, is that order number 834 is not a new restriction added to a list of restrictions. It is the legal infrastructure that makes the entire list enforceable as a system. The decade of external pressure that produced the patchwork also produced the conditions that made replacing the patchwork politically urgent. The consolidated framework is the most precise measure yet of how seriously that pressure was taken, not because Chinese officials said so, but because the chapter structure of the order says so. The constraint is visible in the silicon. It is also, now, visible in the statute. That is a different kind of evidence, and it reaches further than any single chip teardown. Every legal framework of this weight has a first test case, and when that case appears, the distance between the order's text and its operational reach will become measurable for the first time. Which object should we open next? The first enforcement action filed under order number 834 when it surfaces, or one of the specific chip architectures whose design constraints the order was built to protect? Leave the object in the comments and we will put it on the table. If this kind of layer-by-layer analysis is what you come here for, subscribe and turn on notifications so you catch every cut.